All right, testing. Okay, Surface Transportation Board 1182 purchase merger control of motor passenger carriers. 1182 1 application covered by this part. 1182 content application. 1182 3 filing applications. 1182 4 board review of application. 1182 5 comments. 1182 6 processing opposed application. 1182 7 interim approval. 1182 8 miscellaneous requirements. 1182 9 notice exemption. All right, 1182 1. Application coverage for this part, but the rules of this part govern the application of the authority, Title 49 U.S. Standard Code, United States Code 14303, with a consolidated merger purchase to leave the contract to operate with the property for the franchise of motor carriers of passengers or to acquire of motor carriers of passengers. This is no application for the use of the proceedings. Application shall file with the pleading containing the information described in Title 49 CFR 1182.2, see Title 49 CFR 1002F 2 and 5 for filing fees. 1182.2 content application. Application must contain the following information: full name and address, authority of the signature, each of the parties of the transaction, copy of the description, pertinent operation authority. All of the parties note the application is domiciled in Mexico or owned or controlled by the person of the country of the copy of the actual operating authorities must be submitted. A description of the proposed transaction, identification of the motor passenger carriers affiliated with the parties, a brief description of their operation, summary of the inter-corporate structure of the corporate family from the top to the bottom, jurisdictional statement under Title 49 U.S. Standard Code 14303G with the 12 months aggregated with gross operating revenues, including revenues of all of the motor carriers, parties, and all motor carriers controlled by or under the common control of the party of the transportation service with the interstate, and intrastate foreign regulated with the unregulated exceeding $2 million, no more than motor passenger carriers part of the motor passenger carrier. Affiliates may select consecutive 12-month period ending no more than 6 months before the date of the part of the agreement covering the transaction. They must, however, select for the same 12-month period. The statement, including whether the transaction will or will not significantly affect the quality of human environment, with the conservation of energy resources. 7. The information demonstrated the proposed transaction consistent with the public interest, including particularly with the effect of the proposed transaction on the adequacy of the transportation of the public, the totally fixed charges, interest of the result from the proposed transaction, interest of the carrier of the employees effective of the proposed transaction. See Title 49 United States Code 14303B. Certification by application from the current U.S. Department of Transportation safety fitness rating of each of the motor passenger carrier involved in the transaction, whether the carrier is a part of the transaction or is affiliated with the party of the transaction. 9. Certification party acquisition, party acquiring and operating rights for the transaction, sufficient insurance coverage of the Title 49 U.S. Standard Code 13906A and D for the service intent for the provided statement indicating whether any of the party acquiring operating rights for the transaction either domiciled with a Mexico owned controlled by the person of the country, and if the transaction involved the transfer operating authority to an individual who will withhold the authority in his or her name, the individual must complete the following certificate. I certify with the under the penalty of the perjury of the law of the United States that I have not convicted of September 1st, 1989 of any federal state offense involving the distribution, possession of controlled substance that I have been convicted. If I have been so convicted, but I'm not eligible for the received federal benefits either by court order or operating laws pursuant to Title 21 United States Code. 862. Application should contain the applicant's entire case for the support of the proposed transaction left to the board over the total motion of the party of the proceeding and the addition of evidentiary submission of the required to resolve the issue of the particular case. Any statement submitted with the behalf of the application supporting the application shall be verified with as provided in Title 49 1182A pleadings consisting strictly a legal argument. However, the need not to be verified application and supplemental pleading contains false and misleading information granted application over the void be ab initio. Or 1182.3, filing application. Each application should be filed with the board to comply with the requirements set forth in Title 49 1182.8. One copy of the application should be delivered to the first class to operate with the regulatory body, each for the state, with the interstate, when the operation with the effect of the transaction. If the application involved with the merger or purchase with the motor passenger cars, contempting transfer of the operating authority with the registration, one of the more of the parties of the other. One copy of the application shall be delivered to the first class mail to the Federal Motor Carrier Safety Administration, Office of the Registration Safety Information, Chief Registration and Licensing and Insurance Division, 1200 New Jersey Avenue, Southeast Washington, D.C., W65331, Washington, D.C. 2590. An application from the party shall certify that the delivery of a copy of the application provided with the paragraph A of this section. Or 1182.4 board review of the application. All applicants review with the competency. All applications will be reviewed with completeness. Application will be given the opportunity to correct the minor error of the omissions, and complete application may be rejected, or if the omissions are corrected with the filing date of the application, the purpose of the calculating of the procedural schedule statutory deadlines will be deemed to be date on which the complete information is filed with the board. The application, except for the summary of the application, will be published in the Federal Register within 30 days of provided with the Title 49 U.S. Standard Code 14303C to give the notice of the public in form of the tentative grants of the authority. If the published notice does not properly describe the transaction with the approval of the application shall inform the board within 10 days after the publication date. A copy of the application will be available to the Inspection Board Office of Washington, D.C. Interested parties may obtain the copy of the application from the application representative specified with the purchase notice. 1182.5 of the comments. For the comments concerning the application must be received at the board within 45 days after the notice. The application is published with the provided in the Title 49 U.S. Standard Code 14303D. Failure to file timely comments waive the further participation proceeding. If in no comments filing opposing the application, the published tentative grant of the authority will be automatically become effective at because for the comment period, a tentative grant with the authority does not entitle the applicant to consummate the transaction before the comment period. A comment shall be verified provided with the Title 49-1182 AE with a shelf containing the information upon with which the commenter intended to rely, including the grounds of any opposition transaction. Commenter's interest in the proceeding. The docket number of the application must be conspicuously placed at the top of the first page and of the comment, and then a copy of the comment shall be delivered concurrently with the application represented. 1182.6 processing opposed to applications. In-time comments of the submitted of the opposition with the application with the tentative of the grant of the authority is void. The application must file with a reply with the opposing comments within 60 days after the date of the application was published. The reply will include the request of the expedited decision on the issue with the relation by the comments, otherwise the reply may not contain either new evidence and shall only rebut and further explain matters previously raised. The reply shall be verified with the provided in Title 49-1182 AE unless it consists strictly of a legal argument. The application reply must be served with each of the commenter in such a manner that it is received no later than the day it is due to be filed with the board. Opposing comments may reply with a request of the expedited decision within 70 days after the notice of the application was published with the board. May dispense further proceeding and make final determination based on the record of the development. Issue procedural schedule specifying dates for which the applicant must submit the additional evidence for the support of the application and the response to the commenter. Opposition commenter may reply. Further processing and of the application handled the case-by-case basis as appropriate to the particular basis raised during the comments filed with the opposition to the application. Evidentiary proceeding must be concluded within 240 days after the publication notice of the application. Or 1182.7, the interim approval. The party may request the interim approval of the operation of the party sought to be acquired through the proposed transaction for a period of not more than 180 days, depending on the determination of the application. This is requested may include the application may be submitted separately after the application is filed. Once the comment opposing the application has been filed, with the additional filing fee required with the request for the interim approval to include with the application is submitted separately at the later time. See Title 49, 1022 F5 with the additional fee. With the request of the interim approval of the operation profit itself to be acquired, the application must show for the failure to grant interim approval that may result in the destruction of the injury to those property that substantially interfere with the future usefulness, provide adequate with a continuous service to the public. If the request for the interim approval is submitted with the application is filed, it must be served on each person who files and has filed a comment in response to the published notice of the application service must be simultaneously upon the comment whoever known of the request for the interim approval to submit with the otherwise service must be within 5 days after the comment is received by the applicant or their representatives. Because of the basis requesting interim approval is prevent destruction injury of the motor passenger carrier solvent to be acquired in Title 49 U.S. Standard Code 14303. Processing such request with intent to promote expedited decision regarding interim approval. The board has no obligation to give public notice for the request for the interim approval and such a request to decide without hearing or other formal proceeding. If the request interim approval is included with the application of the board with a decision regarding interim approval, the interim approval will be served in conjunction with the notice of the application of the accepting the application. If the application is rejected, request for the interim approval will be denied. If the application is denied, commenters supposing to submit any of the interim approval will terminate 30 days after the service of the decision denying the application. A petition with a reconsidered grant of the interim approval may be filed only on by the person with the filing of the comment with the opposition application. With a petition reconsideration grant with approval that must be written and shall state the specific grounds on which the comment or reply for the opposing interim approval of the petition shall certify that the copy has been served on an applicant representative. The original 10 copies of the portion petition reconsider the grant with the term of approval shall be filed within the board. One copy of the petition shall be served with the applicant representative. The board may act the petition reconsider the grant interim approval to, either separately or in connection with the final decision of the application. 1182. 8. Miscellaneous requirements. If the application withdrawal of the application over the which shall jointly request the dismissal in writing, original 10 copies of the application plus anything other material filed under this part must be filed with the board of pleading and included with the motion replies on the submitted under this part shall be served on all other parties concurrently by the same of the more expeditious means with which they are filed by the board. Except each pleading shall contain the certificate of service stating that the pleadings are served in accordance with paragraph C of this section. E. All applications pleading with the containing of the statement of the fact with the ex motion with the strike with the applies thereof the other pleading of the consistent only the legal argument must be verified with the person offering the statement in the following manner. The name and the title of the witness verified with penalty and perjury under the law of the United States without information supplied with the connection with the application the true and correct with the further I certify with the qualified authorized filed with the application and the pleading I know the willful misstatements of the omission of the material facts constitute the federal criminal violation published under Title 18 United States Code 1001 imprisonment up to 5 years fines up to $10,000 each offense. In addition, these misstatements are punishable for the perjury under 18 United States Code 1621, which provides fines up to $2,000 imprisonment for 5 years of each offense. For the completion of transaction transfers operating authority of registration for one of the more of the parties to others, the party shall comply with the relevant procedure of the Federal Motor Carrier Safety Administration, comply with the ministerial requirements of the relevant state procedures. Art 1182.9. Notice of exemption. Transaction with a motor passenger corporate family is exempt with the Title 49 United States Code 14303. If it does not result in the inverse change of the service level, the significant operational changes, or change of the competitive balance of the motor passenger carrier outside of the cooperative corporate family, the board has found that the prior review and approval of the transaction is not necessary for the carrier of the transportation policy of Title 49 United States Code 13101. Regulation is not necessary to protect the shippers with the use of the market power with the exemption is in the public interest. See Title 49 United States Code 13541A. To qualify for the class exemption, party must be filed with a verified notice of exempt transaction with the board, with the shall contain with a brief for the summary of the proposed transaction, for the name of the applicant, for the business, for the address, for the telephone number, the name of the counsel for whom the questions will answer, for the notice shall be described the purpose of the transaction, give the proposed consumption date of the transaction, which must be at least 7 days after the filing with the notice. For the notice shall describe any of the contracts agreement that have been entered into will be entered within the concern of the transaction shall indicate the impact, if any, of the transaction will have on employees. Board shall publish notice for the exemption with the Federal Register within 30 days for the filing of the verified notice for the exemption. If the notice contains false, misleading information, the board shall summarily revoke the exemption, require the disventure the exemption required the adventure of the petition revoked the exemption of the Title 49 United States Code 13541D may be filed at any time with the grant upon finding the application with the Title 49 United States Code 14303 person class for the transportation necessary to carry out the transportation policy 49 United States Code 13101. Alright, Part 1, 1184 Motor Carrier Pooling Operations. Testing.